Hello, this is Chris Buberg, uh, talking to you today about a workers' compensation issue that comes up pretty frequently. After an individual in Virginia is injured in employment, they're required usually to go and see a company doctor. Sometimes the employer doesn't have a doctor set up and they go to see their own doctor. But if you go to the company doctor, one thing that's for sure is that they are taking a drug screen. They're taking the blood of the individual who's hurt to screen them to test for the presence of drugs. And the reason that they're doing that is because employers in Virginia have a defense to a workers' compensation case, which involves whether or not they were on drugs and that whether or not drugs contributed to causing the accident. So what happens is the test is taken, and if it comes back that the person had drugs in their system, then often the insurance company uses that as an excuse to deny the claim. But the problem is that that's not really what's required. And a lot of people end up ending their case at that point because they're embarrassed. They don't want to admit to the illegality. They are upset that they've been caught using drugs and that their privacy has been invaded in this way. But in Virginia, intoxication is an affirmative defense. And legally, what an affirmative defense means that if the other party, the employer in this case, wants to use that as their defense, they bear the burden of proof on that. So in other words, the employer is going to have to prove that the injured worker was intoxicated and that the intoxication caused the accident. Now that sounds really crazy, and it sounds like that would be really hard to do. And in fact, it is hard to do. In the cases that I've had, I have not lost a case where we've gone to a hearing before a deputy commissioner where they were using the defense of intoxication. And the way that we respond is this: you subpoena the person's supervisor and you subpoena their coworkers. And you ask the supervisor, did he seem intoxicated to you? Did he seem drunk? Did he seem high on marijuana? Did he seem like he was impaired in any way? And usually the supervisor, in my experience, has said no. And you say to the supervisor, now you take a look at your employees, don't you? And you want to be sure, because you're doing dangerous work and people could get hurt. You want to be sure that they're not having any problems that day and that they won't endanger you or the work site or any other workers. And of course they say yes. And then you call a couple of other employees who were hopefully there at the time or saw the person that day near the time of the accident. You say, look, did you see my client? Yes, I did. Did he seem like he was impaired? Did he seem like he was under the influence? Did he smell of alcohol? Did his eyes look like he was on drugs? And when they all say no, the affirmative defense goes away. So the thing is, you can't give up on a workers' compensation case just because of a positive drug test, even though the insurance company, if you're not working with a lawyer, will tell you, well, you failed the drug test, therefore you don't get workers' compensation benefits. They don't have a duty to tell you the law. They don't have a duty to tell you the truth about your case. So you can't rely on what they're telling you when you're negotiating with an insurance company adjuster. That's why you need to talk to a lawyer to make sure that your rights are protected and that you get what you do under the law. And remember, I always tell my clients, never give a recorded statement. Thank you.